The next matter from before us this morning is Rivers Place Limited versus Mormack Industries, Inc. et al. Both sides will have 15 minutes to argue this morning. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, please let me know as I'm keeping the clock. The court has read the briefs and we are ready to proceed with the matter.
Good morning, Your Honors. First of all, my name is James Richard. I represent the appellant, and I'd like to reserve 5 minutes for rebuttal. Good morning, Counsel. I would begin, if I may, Your Honors, by pointing out that both sides, since the original briefs, have filed a statement of additional authority or addressed that dealing with the Beck Energy decision that was issued by the 7th District, which is now on appeal to the Supreme Court of Ohio. There's not been a final decision made, but...
Did they accept jurisdiction?
Not yet.
Oh.
It's briefed. There's no ruling by the Supreme Court of Ohio. Here, I think we have a different lease terms, but other than the breach of contract claims, the substantive law claims, Your Honor, is dealing with breach of the implied covenant, continued development, public policy arguments, lease reservation, forfeiture, are all in those briefs that have been filed at the Supreme Court. So there is a similarity of issues that may very well apply. But what I want to start with initially, Your Honors, is in this case, unlike the Beck case, we have clear contract terms. We have terms that required the payment or tender of payment of delay rental payments if there's no payments or sale of gas and oil for a period of 1 year. That did not happen. There was no tender or no payment for more than 1 year. So we're not here talking about other terms or temporary cessation of production. This isn't about production per se. We have a contract clause that was clear and unambiguous. And what happened in Beck, they also interpreted the contract. In that lease, there was a clear contract provision negating the implied covenant of continued development. There was also a clear contract provision saying there could be no default declared until the lessor, the landowner, gave notice of the default and an opportunity to cure it. I think the 7th District made a decision in Beck based upon contract terms saying you have a 10-year lease, you agreed to accept delay rental in lieu of drilling as long as it was paid annually, and after 10 years you had to drill. They simply interpreted the contract literally and didn't go beyond the four corners of the instrument. Now here, and there's no language as well that says in the discretion of the lessee or is the well capable of production as determined by the lessee. Those provisions do not exist. So here, going to the other arguments briefly, we have a perpetual lease, according to testimony in Mormack as submitted to trial, basically saying we have a nominal well that may or may not be producing in commercial quantities, but I alone, I being Mormack, am going to determine when and if are developed the remaining acreage and the remaining formations. We don't have that in Beck. We have testimony saying, are you going to do deeper well drilling? The answer is, at trial, why should I? He also went on to testify that I alone have the benefit of receiving income from a windfall. I don't think it's worthy of commercial production or additional drilling. But I alone want to set on this lease in perpetuity. He didn't say 5 years. He didn't say 10 years. He didn't say 50. His testimony is, I drilled a well in 1980. I guess it's paid out. It may or may not be worthy of commercial production now, but I'm going to sit on this undeveloped acreage in perpetuity, hundreds of years, with no additional consideration. So I think that's...
Excuse me, it seems to me as if trial court listened to conflicting testimony as to the production, how long the well was down, and testimony as to whether or not there was some mistake in payment and in credit given and so on and so forth, and appear to credit the testimony of the appellees with regard to whether a factual finding as to whether the well was not producing for over a year. So we're looking at it almost like manifest weight. Was the determination against the manifest weight of the evidence? Would you agree?
That's my second assignment there on the breach of contract terms, Your Honor, Judge Moore. And also on the last assignment there, where the court granted the request to bifurcate and denied my right to jury trial. Yet the court went in and said, apparently at the end of the day, I think there is conflicting evidence. I'm going to find this. And that's why I included that assignment there, because if there was a question of fact for the trier of fact, it wasn't a question of law. It should have gone to the jury. But to go back to this, Judge Moore, this is not about, I submit respectfully, production and a temporary cessation of production. It's about a contract term that says, if you're in good faith, you have a problem, a downhole problem, hole in the casing, it has to be fixed, that happens. But you still have to keep paying. You still have to pay the delay rental. He interpreted this right out of the lease, saying, I'm not paying, I don't have to. And at the end of the day, his first excuse was, the lease is held in production. That was his response under oath to the affidavit of forfeiture. His second explanation was, the landlord's getting free gas and that's enough. And as you know, the case law in Ohio says it isn't enough. So he retracted that. Then he said it was a gas-only lease, which he recanted. And 3 months into the litigation, he and his lawyers came up with this mistaken overpayment. But the amazing issue about that is, he didn't have the documents. He even admitted, he said he remembered his secretary doing something, trying to be accurate here. He knows something was sent out, but he couldn't find a copy, so he recreated it and wrote his own notes on it. And that's not disputed either. He said, I know this was sent somehow. I can't find my copy, but here's what I remember 3 years ago was on it, and he recreated the document. So, yes, in that context, if there is a question of fact on the breach of contract claims, the manifest weight of the evidence is asserted here. But I'm back to strict contract terms, just like in Beck. And if we can do, Judge Moore, what's your question? If we can interpret the lease and make Mormack the sole arbiter, that they didn't have in Mack either. Then we're running right into the public policy arguments.
But you keep saying to make him the sole arbiter. As I understood the terms of the lease, if there was longer than the first term was, is there a year of non-production, at least a year? And then if there isn't, if you go beyond a year, give you the benefit of the doubt that there was a year that there was not production, then the contract provides for the delayed payments. But what you're asking for is for us to say, just forfeit the lease and determine that it's against public policy. But the very terms of the contract appear to say what it is that you do. You have to make some delayed payments.
I submit, again, it isn't just production. You don't have to show production. You have to show that there was no, and my client did, there was no payment of the delay. There was no payment or tender of gas payments. Although there was apparently gas sales. We didn't know about that. But there was no payment or tender, to use the contract language. That is the first assignment there. And he did not comply with that. The question, the trial court did make that finding, which we submit to be incorrect, that it's all about production. Your clients didn't know it, but he had a downhole problem. He fixed it in good faith. And although you didn't get any money, that's fine. These things happen. In all the case law in this jurisdiction and other jurisdictions, when you're dealing with a temporary cessation of production, that does apply. But I submit we're not dealing with temporary cessation of production. We not only didn't get any money for over a year, the lessee interpreted the lease to say, I don't have to pay the delay rents. And I don't have to tender the payments. I don't have to send you a check for $100 an acre or whatever it is to keep the effect, and that is the clear contract term. Judge Moore, I respectfully submit the other issue is, does this nominal production hold the lease in perpetuity as to all formations in the sole judgment of the lessee? And I submit that it does not. Now,
Was this a gas and oil?
yes.
That's what you're just now reaching through the document. Okay.
Stop, thank you.
Thank you. May it please the court. My name is Kim Hall, and I represent Mormack Industries and Paul McCloskey Jr. in this proceeding. Each of Driller's Place's assignments of error is undermined by two essential facts, which Driller's Place fails to acknowledge. First, the well was out of production for approximately 4 months for time of repairs. And second, there was an overpayment and subsequent credit to Driller's Place's predecessor in title, which explains why the landowner didn't receive actual checks for a period of time.
He's claiming that there really wasn't any documentation of that.
The documents he was referring to at trial, Mr. Ed Mack, president of Mormack Industries, he testified that he noticed his secretary made the little notation on the statement to Mr. Hilty, and he recalls her sending it out. He doesn't have an actual copy of it because he doesn't keep copies of those documents. It was just a little handwritten notation that he saw his secretary put on there. So during the course of discovery, he wanted to make the opposing side aware of the sort of notation that was on there. So he doesn't have a copy of it, but he testified that that notation was made and it was sent out.
And I know you, I can't remember exactly, but I know you have something in the briefs about the accounting. And so that was presented at trial to demonstrate the overpayment.
Yes, Your Honor. There is a difference. It's an accounting process Mormack uses. There's a difference between the accounting period and the production period. The accounting period basically just shows when the landowner was paid, but it doesn't necessarily show when production happened under the lease. So they were relying on the document showing the accounting period to show that there was a lapse in production, even though the document they were referring to didn't show the actual production. And when the two documents are read in conjunction with each other, you can see that there was significant production throughout the period of time they claimed that there was no production. As for the implied covenant of reasonable development argument, first in the lease there is an express drilling commitment to drill one well only. And even ignoring that altogether, the only evidence presented at trial was that Mormack did comply with this implied covenant. The only evidence presented at trial was that Mormack, approximately half a dozen times throughout the years, conducted studies on this property to see if it would be feasible and economical to drill another well, and Mormack determined it was not. Mormack conducted seismic studies, which basically send sound waves into the ground to see if there are other formations and some oil and gas that they could drill. And they found that there was no such oil and gas that they would drill at this time. Driller's Place presented absolutely no evidence to the contrary. Driller's Place presented no expert testimony that other acreage could be drilled or would be productive. Mormack is not required under the law or under the lease to act to its detriment and drill a possibly unproductive and unprofitable well. As to the delay rental payments, Mormack never disputed that no delay rental payments were made because no delay rental payments were due. This is because the delay rental provision only applies during the primary term of the lease, and this was reflected in the Hub Feedback Energy decision on paragraph 91. It says, quote, delay rental provisions in oil and gas leases apply during the primary term of the lease, end quote. And even if the delay rental provision somehow applies to us because we're in the secondary term and not the primary term, that delay rental provision is only triggered when the well is out of production for a period of a year or more. And here, as I stated earlier, the well was out of production for approximately 4 months. So the payment or non-payment of the delay rentals is immaterial because we're in the secondary term of the lease and there are no set of circumstances under which Driller's Place would have received those delay rental payments. And as for cessation of production, courts universally recognize that a mere temporary cessation of production doesn't terminate a lease under its addendum clause when the operator exercises reasonable diligence in putting the well back into production. Here, Mr. Mormack testified at trial that a downhole problem was discovered with the well in April 2011. The well was out of production for approximately 4 months for the time of repairs, and the well was put back into production before Driller's Place ever purchased the property. Moreover, Driller's Place has cashed certain royalty checks that were sent after the well was put back into production. Turning to the public policy arguments, in its brief before this court, Driller's Place relies heavily on 2 cases involving the Beck Energy leases, and this is Hub v. Beck Energy and Belmont Hills v. Beck Energy. The leases in those Beck Energy cases are different from this lease in every important way. As Mr. Richard acknowledged earlier, those leases contain discretionary language. The leases specifically say the secondary term continued on so long as oil and gas was produced or capable of being produced in paying quantities in the judgment of the lessee. And in both of those cases, there had been no development of the property, and they were both in their primary term. Here, there is no language in the lease allowing for Mormack to self-determine if the well is capable of producing. The lease just states it continues on as long thereafter as oil or gas, or either of them, is produced by the lessee from said land. The secondary term here continues on for the time of production. The well either produces or it doesn't produce. And the mere temporary cessation of production, as has happened here, isn't sufficient to terminate the lease. And lastly, I want to address the procedural arguments Mr. Richard brought up. Driller's Place's arguments ultimately focused on credibility issues. And here the trial court was the correct arbiter of the claims, and therefore the trial court had the right to make those credibility determinations. The motion to bifurcate the trial was fully briefed, and it was clear that Driller's Place did not have a right to a jury trial on all but one of its claims. Each of its claims, except for the slander of title claim, sought only equitable relief. The trial court properly denied the slander of title claim on its own motion. The claim solely involved the contents of Mr. Edward Mack's affidavit, and the affidavit stated that the lease had not terminated. The court found that the lease had, in fact, did not terminate based upon its credibility determinations. Because the claim was dependent upon a determination that the lease had expired, no issue remained for a jury to decide. In its brief, Driller's Place itself stated that only if questions of fact remained should that issue be submitted to a jury, and that's on page 13 of Driller's Place's brief. And further, Driller's Place initiated questioning on the slander of title claim by questioning Mr. Edward Mack about his affidavit. And in conclusion, the thrust of Driller's Place's argument is that Mormack abandoned the well in payments to Driller's Place and refused to develop the property. This is contrary to evidence in the record. The well has produced for 30 years. Production ceased for approximately 4 months. The well continues to produce, and Mormack continues to send royalty payments. For these reasons, I ask the court to affirm. Do you have any questions? Thank you.
Your Honors, I will try to use my 5 minutes as best I can here. First of all, I have to take issue with several comments that were made. The delay rental or shut-in royalty or those provisions of the lease do not apply only in the initial term. They kick in several instances. Obviously, if you take it to the extent or logical extent the counsel is arguing, if there was a problem downhole we didn't know about, that could go on for 9 years with no payment. We wouldn't know. And then Mormack could come forward and say, contractually, I interpret that differently. I don't have to pay. I didn't have to pay that delay rental payment. The lease clause says, lessee shall pay or tender as royalty an amount equal to the yearly delay rental as provided by the provisions of the lease payable annually. They didn't do that. The temporary cessation of production has nothing to do with that. You could go on for years and never pay it. You could be selling gas and never pay it. But to argue the delay rental provisions only apply until a well's drilled is incorrect. The Beck decision did find that in the primary term analysis. There was no well ever drilled in Beck. The primary term was 10 years with annual delay rental payments, and after that, it did go into the secondary term. But Beck also said it is not whether the land is capable of production. What counts is development and payment for the mutual benefit of the lessor and lessee. So in other words, we have here Mr. Mormack saying, for the next 200 years, I'm doing nothing. I'm tying up your acreage indefinitely, and I'm not going to try to develop. Going to the issue of economic feasibility, that's also in Beck. It is not economic feasibility. The Supreme Court, in the Sauer case, the Supreme Court case, they talk about it has to be for the mutual benefit, and the mere fact that the lessee concludes, I'm not going to drill now because I don't think it's feasible, is not enough. That triggers forfeiture of the undeveloped acreage. We're not here asking that Beck give us this, nominal well that's out there. Beck still owns the well. The case law is clear. We're talking about the forfeiture or the breach of contract result being keep your well that you think is so worthy of production, you think is so wonderful, it's all yours. And but the undeveloped acreage is gone. You breached a lease, you can have your well, but don't tie up my undeveloped acreage. Let somebody else go out there and spend the money that wants to develop. Don't let Mormack sit there in perpetuity and say, if there's a windfall, I'm going to get it and you're getting nothing. And now what we have unique here, that is his actual testimony. He says, I am the only one that's going to benefit. I have the right to that. And I'm not going to do a thing forever. I'm sitting on this old well. Now, the jury trial issue, counsel correctly referred to what the court did on the slander title claims. But counsel ignored Judge Moore's comment, and that is, we jumped into the interpretation of this lease and this mistaken credit and conflicting evidence, and I'm going to take that conflicting evidence and decide in the favor of lessee. That's why I said that was a wrongful denial of my client's right to a jury trial, and I timely made those objections. One other thing about the credit for overpayment, and that was the fourth excuse that we heard from Mormack. That came up only after discovery. There were working interest owners in this well. There were no records presented. He did acknowledge that he didn't apply the credit to himself and the remaining working interest owners. He had no explanation of that. So what do we have here? We have the fourth excuse during litigation of this mistaken lost quarterly statement that was sent out that nobody could find, that the landowners denied ever receiving. And then he didn't apply credit to himself. He didn't apply credit to any one of his working interest investors. But what else was he doing? He was sending letters, and I'm sure you've seen this in the brief, to those working interest people, taking their lease back for nominal consideration or banking interest in the increasing his ownership percentage, so he could sit on this in the event of a windfall. So the banking of his ownership interest is another reason to consider the public policy arguments, the lease reformation, and the forfeiture arguments. Why is he going out there and telling his people he has a fiduciary duty to, I got a downhole problem, it's not worth production, I'll give you $200 for your working interest. That's in the record. He's banking, he's buying all that stuff back and then telling the landowner, I'm going to sit on this forever. And if there's a windfall and the shale develops in this area, if it ever does, I only am going to get it. That is the question this panel has that I think is unique. And I've been watching all these cases. Am I finished?
Yes, you are.
Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision to be sent to both sides as well as posted on our website